he was here. This is the April 21st, 2015 hearing of the Assembly Committee on Consumer Protection and Privacy. We had Mr. Daly here for a minute, and I know he just stepped outside, so then we will start as a subcommittee as soon as he returns. I see that we have Ms. Chang with us. Just want to make an announcement that file item number 6, which is AB 817, has been pulled from the committee agenda by the author. So again, file item 6, AB 817, has been pulled from the committee agenda by the author. So let's start as a subcommittee, and we have Ms. Burke here to present file item 9, which is Assembly Bill 1129, which enjoys a due pass recommendation.
Thank you, Mr. Chair and members. AB 1129 helps ensure the consistency and quality of data collection across our network of emergency medical services, or EMS providers, as they transition to electronic patient records. A key requirement for any electronic patient record in EMS, it is compatible with both state and federal standards. AB 1129 requires EMS data collection systems to be compliant, but also ensure flexibility to that, so that providers can choose software and hardware packages that best fit their systems, so long as they work with the local EMS authority's data collection system. For smaller EMS providers, or those like our air ambulance providers that serve multiple jurisdictions, allowing for flexibility strikes the right balance between accurate data collection and provider choice. I've been working with EMS providers and the EMS Administrators Association of California on amendments that will address their concerns. I will continue to keep you and your committee staff up to date as we finalize the amendments for the floor. I respectfully ask for your aye vote.
Terrific. And if you indulge us for just 1 second, we will go ahead and establish a quorum so we can vote on your measure.
Gatto.
I'm here.
Wilk. Baker. Calderon. Chang. Chow. Cooper. DeBobne. Dolly. Gordon. Lowe.
A quorum is present. Let's go to your first witness in support.
Thank you. My name is Bob Berry. I'm representing the Ambulance Association of Orange County, and we're in support of this bill. 1129 will actually encourage and allow better data collection in terms of having a standardized format for the LEMSs to collect, to process they'll pass it on to the state, and then the feds actually use that data also. And it's really important in that it really looks at trends and analysis for different protocols and different other things to use in the field to enhance patient care and the delivery of EMS services. One of the bigger issues is part of healthcare reform is holding costs down. And what we're seeing now is where the individual LEMSs start to mandate particular software versus the goal of it's the data, versus mandating a process. And so we're really kind of concerned with that, as it's about the data and not about any individual county establishing a particular software item to use. And whether you're a small provider, you've already invested in one, and you'd have to change, or you're a larger provider that serves multiple jurisdictions, you end up having to invest in 2 or 3 or 4 different software packages and then try to train your employees to use each one of those if they happen to cross jurisdictional lines. So we urge your support of the bill.
Perfect. Next witness.
Mr. Chair, members, Chris McKaylee on behalf of the California Ambulance Association, and I think the best way to understand this bill, as one of our member companies said, what the LEMSs are doing is effectively saying ambulance companies can only utilize Fords to be ambulances, which obviously makes no sense whatsoever. They shouldn't mandate the particular software or hardware that EMS providers utilize. Thank you.
Got it. Is there public comment in support? Seeing none. Witnesses in opposition? Seeing none. Bill's been properly moved and seconded.
I respectfully ask for your aye vote.
Terrific. Madam Secretary, please. Oh, and the motion, of course, is this is due pass to just due pass. All right. Call the roll.
Gatto.
Aye.
Gatto, aye. Wilk. Baker. Calderon. Chang. Chang, aye. Chow. Chow, aye. Cooper. DeBobne. DeBobne, aye. Dolly. Dolly, aye. Gordon. Gordon, aye. Lowe. Lowe, aye.
Your bill has passed, but we will hold the roll open for others to add on. Thank you very much. All right. Next, we have Well, we have no non-committee authors present, so we can go to the committee if there are committee members. Well, actually, you know what? We'll do the consent calendar next. We have a motion by Mr. Daly, seconded by Mr. Lowe. This is the consent calendar. Madam Secretary, please call the roll.
Gatto.
Gatto, aye.
Gatto, aye. Wilk. Baker. Calderon. Chang. Chang, aye. Chow. Chow, aye. Cooper. DeBobne. DeBobne, aye. Dolly. Dolly, aye. Gordon. Gordon, aye. Lowe. Lowe, aye.
Consent calendar is adopted. Let's go to Mr. Gordon if he's ready. Mr. Gordon has two bills before us. First one is Assembly Bill 241, which has to do with bankruptcy. The floor is yours.
Thank you, Mr. Chair and members. Assembly Bill 241 would give a voice to retired employees in local agency bankruptcy proceedings. Under AB 506, which was signed into law in 2011, prior to a public agency filing for bankruptcy in California, it must either declare a fiscal emergency or go through a neutral evaluation process with interested parties. Ideally, these interested parties, creditors, bondholders, and employees, work with a public agency to reorganize debt while avoiding bankruptcy. That law specifically referenced participation in these proceedings by a representative selected by an association of retired employees of the public entity. However, unlike other creditors, individual retirees are not generally in a financial position to participate in these proceedings, or are they organized to do so collectively. To solve this problem, AB 241 would, under specific circumstances, require the public entity to provide retiree contact information to a 501c5 organization for the purpose of advocating on behalf of the retirees' financial interests. I'm pleased to take the language outlined in the committee analysis to, one, set a civil penalty for misuse of this private information at the cost of $25,000, and to allow retired employees or their beneficiaries to opt out of this disclosure. This legislation attempts to address a narrow circumstance where there is a practical need to share information for the organization of retired employees. I respectfully ask for an aye vote.
Terrific. Let's go to your first witness in support.
Mr. Chair and members, Pat Moran with Aaron Reed and Associates, representing the Retired Public Employees Association. This came to RPEA from some of their members in Stockton. The city of Stockton went bankrupt. The retirees from the city formed a 501c5 for the purposes of hiring a bankruptcy attorney to represent them in the bankruptcy proceedings. They found it difficult to reach out to their fellow retirees since they didn't have the names and addresses of the retarees. They made a Public Records Act request of the city and received no response asking for the names and addresses. They eventually got enough of them and contacted retirees and solicited funds so they could hire a bankruptcy attorney, whom they still retain because of the appeal that's ongoing. So they came to RPEA and asked, in a very narrow circumstance, if we could run legislation that would allow them to get the names and addresses of retirees from a local jurisdiction should they file bankruptcy. And that's what this bill does. It's a very narrow circumstance. We hope it'll never be used. We don't want locals to go bankrupt. But should they go bankrupt, we want the retirees to be protected. During the bankruptcy proceedings, the retirees lost $500 million in health care, and they could have potentially lost two-thirds of their retirement check, which they didn't, and they attribute that to their ability to have a bankruptcy attorney represent them in the proceedings. And with that, we encourage your aye vote. Thank you.
Terrific. Let's go to your next witness.
Mr. Chairman, members of the committee, Christy Baumer representing the California Professional Firefighters. We are not officially on record in support, but we are in support of this bill. The author and sponsor came to us about the very narrow application of the release of this information. and we support its concept and tenets, and we urge your aye vote.
Is there public comment in support? Are there witnesses in opposition? Seeing none. Questions or comments from the panel? Seeing none. Bill's been properly moved and seconded. Would you like to close?
Just respectfully ask for an aye vote.
Terrific. Madam Secretary, please call the roll.
The motion is do pass as amended to appropriations. Gatto.
Aye.
Gatto, aye. Wilk. Aye. Wilk, aye. Baker. Calderon. Chang. Aye. Chang, aye. Chow. Aye. Chow, aye. Cooper. DeBobne. Aye. DeBobne, aye. Dolly. Aye. Dolly, aye. Gordon.
Aye.
Gordon, aye. Lowe. Aye. Lowe, aye.
Don't forget.
Terrific. That bill is passed. We'll hold the roll open for the additional members to add on. All right, next, you have a little tiny bill called Assembly Bill 287 that we've been focusing some time on. Mr. Gordon, the floor is yours.
Great. Thank you, Mr. Chairman. First, I'd like to start by thanking the committee for the thoughtful analysis and the suggested amendments to strengthen the consumer protection aspects of this bill. Briefly, those amendments found on pages 11 and 12 of the analysis would have the rental car provisions of this bill track pending federal legislation. It would ensure that this bill does not undermine existing consumers' legal rights, and it would ensure that loaner vehicles provided to consumers have recalls repaired. I would like to take those amendments as author's amendments. In 2014, there were nearly 64 million vehicles in the United States subject to recall. That amounts to about 1 of every 4 cars on the road today. While that number is shocking, early indications are that the number of recalls in 2015 may be even greater. Unfortunately, in many instances, getting the recall service completed is not as simple as calling a franchise dealer and making an appointment. Notification of vehicle owners is a challenge. And even when notice is received and the owner seeks a repair, the manufacturer may not have the requisite parts available, and in some instances, the wait for parts may be several months. AB 287 attempts to comprehensively address the recall issue, albeit in different ways, for all vehicles in retail commerce, whether they are sold by a new car dealer, a used car dealer, a private party transaction, or are rented by a rental car agency. The basic concept behind this legislation is that we need to first provide consumers with information so that they can make an informed choice when purchasing a vehicle. That secondly, we need to incentivize the repair of vehicles subject to recall, and third, when necessary, prohibit the sale of some vehicles until the repair is completed. There will be folks appearing in opposition with a position that all cars need to have recalls repaired now. Fundamentally, I agree with the opposition. We do need all vehicles subject to recall repaired as soon as possible. Let me repeat, I agree. However, that is hardly the status quo. And I believe that the approach taken in AB 287 represents what is practical and possible in the current recall environment, where required parts to repair a vehicle may not be available for months after recall is announced, where existing law imposes no restrictions on the sale of cars with an open recall, and where consumers may not be aware of the recall status of vehicles. The approach in 287 ensures that manufacturers and dealers both have skin in the game and that consumers are better informed. Let me walk you through the landscape of existing law and what 287 does. Under existing law, there is no restriction on the sale or rental of a used car with an unrepaired recall. Moreover, there is no requirement of notice to a consumer of the unrepaired recall. Now, I'd note that some companies have voluntarily taken a different approach. The big 3 rental car companies have agreed to repair recalled vehicles before renting, and these companies should be commended for their approach. But let me repeat, there is no requirement in law to repair a vehicle or notify a consumer. So AB 287 would inform owners to stop driving a vehicle or when car dealers are selling vehicles. That would prohibit new car dealers, used car dealers, and rental car companies from selling, leasing, or renting those vehicles that are under stop drive, stop sale. Secondly, for recalls designated as stop drive, stop sale, AB 287 would require these entities to check a qualified recall database prior to selling, leasing, or renting any used vehicle to consumers. And if a new car dealer, such as a Ford dealer, has a used Ford on his or her lot, because that dealer is in the best position to see if the vehicle is repaired, AB 287 would prohibit the dealer from selling that vehicle until the recall is repaired, regardless of how long it may take. If a vehicle is not of the same line as the dealer's franchise, such as a Ford dealer having a used Chevy on their lot, or if it's for sale by a non-franchised car dealer, AB 287 would require the dealer to disclose the recall to the consumer, provide a copy of the recall notice, and inform the consumer that he or she can get the recall repaired at no cost at a car dealer of the vehicle's make. As noted above, the big three rental car companies have pledged to ensure that all rentals are repaired. As the bill will be amended pursuant to the committee's analysis, AB 287 would largely track a pending federal bill that would require vehicles to be repaired or the recall prompting defect mitigated prior to even renting the vehicle. The federal bill is supported by the big rental car companies and numerous consumer groups, including some that are currently opposing this bill. For private party sales, which amount to 60% of used car sales, AB 287 would require private party sellers to inform potential buyers of any and all recalls prior to sale, similar to the current requirement around odometer disclosure. Finally, AB 287 would require auto manufacturers to provide consumers with a loaner vehicle at their request and at no cost when consumers seek to get a recall corrected and the parts or procedures are not available for repair. The committee analysis did an excellent job in characterizing some of the challenges with a bill that attempts such a comprehensive solution. And the amendments today, I believe, strengthen the bill, but I will admit that there is more work moving forward. Colleagues, the bottom line is that it appears that we've entered a new era of increasing auto recalls. Existing law fails to require that dealers repair any recalls, that vehicle purchasers are notified of an open recall, or that consumers are provided with an optional loaner while awaiting repairs. I would respectfully request that you join Assembly Members Eggman, Jones, Stone, Wilk, and me and vote aye on AB 287. And I do have witnesses.
Terrific. Let's go to your first witness.
Thank you, Mr. Chair and members. Cliff Costa on behalf of the California New Car Dealers Association. I'd like to thank Assemblymember Gordon for doing an excellent job describing what the bill does. So instead, I'll take a moment of your time to explain why car dealers, especially California's new car dealers, are sponsoring this measure. For the past several years, California's new car dealers have faced a piece of legislation that failed to pass this House that was overbroad and was a one-size-fits-all solution. Following those bills' failure to pass, we decided that it was time for California's new car dealers to get our hands around the issue comprehensively and to try to address this issue of recalls, even though this is not a problem that we created. AB 287 is the only measure in the country that seeks to address this measure from both new car dealers, used car dealers, rental car companies, manufacturers, and private party sellers. The CARS Act is intended to ground the most serious recalled vehicles, inform consumers when they are purchasing a vehicle about open recalls, and to help provide loaner and rental vehicles to consumers who are your constituents and who are driving around today with open recalls that they cannot get fixed because parts are not available. And with that, I'd like to yield the rest of my time to our contract lobbyist, Mike Belote.
Welcome.
Thank you, Mr. Chair and members. Mike Belote, also on behalf of the California New Car Dealers Association. Mr. Gordon and Mr. Costa have gone through the comprehensive nature of this, how it does bring in every aspect of retail commerce in vehicles that we can think of. We've had really robust discussions with many of you and your staff and the majority and minority committee staff. There have been excellent points made, and I wanted to talk about two of them. The first relates to this question of rental cars. And the argument was made that the transaction decision in a rental car transaction is very, very different from a used vehicle. That one will get to the booth, if you will, at the rental car agency, kids in tow, you're ready to go to some happy place, happiest place on earth. At that point, being given a disclosure about the recall status of the car, will be difficult and awkward and may not present consumers with the best choice and time of choice. And frankly, there's some truth to that. The idea is that in a car purchase, you have a decision that you can put in the hands of the consumer. When they know what the recall status is, they can choose to walk away, and frankly, we are very sure that consumers in many cases will choose to do exactly that. So it did make sense to us, after discussing it with the committee and with the opposition, to treat rental cars differently than the sale by new and used car dealers. As Mr. Gordon noted, the rental car company should be applauded, not harmed, by voluntarily agreeing not to rent recalled cars. And so we do not wish to put the rental car companies to inconsistent federal and state standards. They should be the same. And so we pledge to work diligently to make sure that the rental car companies are held to exactly the same standard here in California that they have proposed in the Boxer-Schumer bill in Congress. So the two standards ought to be the same, and we will work with them to make sure that they are given the credit they deserve for taking this voluntary action. Second, with respect to the consumer, him or herself, the argument was made that in some way the consumer could actually be worse off if the bill passed by having received a disclosure from a seller that they have therefore agreed to buy the car and have somehow contributed to their own problem. And that was never our intention. We never wanted the consumer to be worse off than they would have been had they not received any disclosure at all. We want this to help consumers, to give them the information that they need to decide whether to purchase the car or not. So we have worked with the committee and with the opposition, and the language now takes three important amendments. First, it says that the disclosure has no legal effect on any subsequent litigation except to show that we actually made the disclosure, so that if a question arose, did you hand the consumer the disclosure or not, we can show that we did. But other than that, there is no legal effect on the consumer. They're in exactly the same position they would have been before. Second, to put belts on that suspenders, we say that in no circumstances should the consumer as a plaintiff be worse off as a matter of law than they would have been had they not received the disclosure at all. And third, to further buttress this point, we say that the bill has no effect on existing legal rights or remedies under statutory or common law. So the consumer's ability to be made whole remains whole. And I think that was always our intent, and it was pointed out by the opposition, and we were pleased to try to clarify that with the amendments to the bill. So there is no law anywhere. Mr. Gordon said nothing preventing a dealer now from selling a used car subject to a recall. We are aware of no prohibition in California or nationally, and this is a chance for California to lead. Consumers will be better off with the passage of this bill than they are now, where no prohibition exists. So we strongly ask for an aye vote.
Thank you. Next witness.
Good afternoon, Mr. Chairman and members. Billy Doring, representing the Independent Auto Dealers Association. We represent the used car dealers. I will try to be brief, as Mr. Costa, Mr. Gordon, and Mr. Belote have covered a lot of it. But absence of this bill leaves the consumer with zero protection whatsoever. Last session, we had a bill that just said that dealers had to disclose the recall. However, there was nothing to get the recall information from. Now the feds have adopted a database that we can get to prior to us selling the car, notify the customer that there is a recall, and we feel as an industry that we have an obligation to take care of that and make the notification. Nobody should get hurt because of a recall. And before we didn't have the tools, now we have it. There's no reason to oppose this. We would encourage the committee to support it, as it does help the consumer, because right now, and if this bill fails, the consumer will be worse off than they really are because it's out there. And as it relates to rental car companies, they are to be applauded, because rental car companies are no different than a legal owner, because they get the notice And used car dealers and new car dealers never get the notice, but now they will. We would urge your support.
Thank you very much. Is there public comment in support? Are there witnesses in opposition? Please come forward.
Yeah.
Welcome.
Mr. Chairman, my name is Mark Anderson. I'm a lawyer, a practicing lawyer in San Francisco. For over 30 years, I've represented car buyers in cases involving dealer fraud cases, lemon law, and that sort of thing. I'm also here representing the National Association of Consumer Advocates. It's a nationwide association of attorneys who do consumer law generally, and in particular represent car buyers. We oppose this bill. The premise of the author and car dealers seems to be that right now there's no law, there's a void, and we need to fill it with something. They are mistaken on that. They are clearly mistaken. Right now, it is illegal for any car dealer to sell any vehicle that's unsafe. If it's unsafe, it can't be sold. That's true under the vehicle code. It's true under other statutes. The implied warranty of merchantability applies to many sales, and so the whole premise of their bill fails. And the problem with passing this bill, number one, is that it would create a huge exception to that law. Ironically, it'd be the cars that have safety defects as determined by the manufacturers can be sold. And yeah, there's a notice that's handed to the car buyer, but the problem is consumers don't always understand those things. Sometimes some dealers just say sign here, sign here. They don't even know what they're signing. They don't read them. And then inevitably they take the car home, and there's a time gap between when they buy it and when the thing can be resolved by the new car dealer. I'll give you an example of a case. A fellow named David Clayton bought a Dodge Ram in Visalia in 2013. It was a 2009 used one. Unbeknown to him, it was subject to a recall, a Chrysler recall having to do with the drive shaft disconnecting from the rear axle. And 2 months later, he's driving down the freeway 60 miles an hour, and that's what happened. Drive shaft falls on the ground, hits a gas tank, didn't blow up. He was lucky, nobody got no personal injury. He found out about the recall when his wife, after the accident, his wife checked online, and there it was. He talked to the dealer, and the dealer said, hey, what about this? And the dealer says, well, gee, we couldn't get the parts. Parts weren't available, so they sold the vehicle anyway. So this is bad. This bill is, on the surface, gee, maybe it helps. No, it hurts. Also, there's another factor. The federal government, NHTSA, National Highway Traffic Safety Administration, as you know, regulates in this area. They should be weighing in on this bill. It's my understanding they didn't have time to send a representative. One thing we urge is that the committee hold the bill till a NHTSA representative can show up and give them their views.
Next witness.
Mr. Chair and members, I'm Rosemary Shahan, President of Consumers for Auto Reliability and Safety, and we're based here in Sacramento. We work on the state and federal levels on a whole range of safety issues, and we're working very closely with Senators Schumer, Boxer, Feinstein, and McCaskill, and others with our allies in the rental car industry to enact federal legislation that would apply in every state regarding rental cars. And we've also been working closely with the Obama administration, which has a very strong position at the U.S. Department of Transportation and the National Highway Traffic Safety Administration, calling for rental car companies and used car dealers to adopt the same good practices and not to either rent or sell unsafe cars to consumers. Under existing federal law, it's a federal crime for a car dealer to sell a new car that is under a safety recall. And while there is no equivalent federal statute that prohibits that yet, there are two bills that have been introduced in Congress, one by Senators Markey and Blumenthal in the Senate and the other in the House by Representative Schakowsky, that would create that same bright line standard. And it just says when it's under safety recall, the dealer should fix it before it goes out on the road. And we would encourage the car dealers to get behind that legislation instead of coming to states like California and trying to undermine the administration and the attempts in Congress to improve safety across the board. And there should be no question that this bill would create a standard that actually makes absolutely no sense. You've heard the author and the proponents say that the intent of the bill is to make sure that vehicles that have serious safety recalls are addressed, and that in the case of other recalls, that consumers would get notice. But it's important to know that when it comes to do not drive, there is no federal standard regarding do not drive. There is no federal definition. There is no mandate. The National Highway Traffic Safety Administration does not have the authority to tell auto manufacturers that they have to tell their customers not to drive their cars. And there are real practical reasons why manufacturers are reluctant to do that. Cars are not like toasters and other consumer products. People depend on their cars to get to work. There's just a practicality issue there where, even if the car is terribly unsafe and known to be terribly unsafe, it's just not practical to tell millions of people overnight suddenly you can't drive your car. So I brought a chart that shows, this is in response to a letter that Senator Boxer and Senator McCaskill sent to the National Highway Traffic Safety Administration asking the NHTSA authorities to require data from the manufacturer regarding do not drive. And historically, when they have chosen to opt to advise their customers, it's not a mandate. They can't tell you can't use your own property. It's their advice to the consumer. And if I could give this to the sergeant, please, to hand out so you can see the chart for yourself.
Sure, we're happy to accept the handout. And we're going to go to the next witness in opposition. Thank you.
Thank you. Good afternoon. I'm Nancy Peverini on behalf of the Consumer Attorneys of California. We did have an oppose unless amended position. We'd like to look at the amendments with our members and see if that changes our position. But I would like to thank the author and the sponsors for at least taking some of the amendments we asked for regarding making sure that evidence is that information that somebody signed a waiver isn't then admissible against them because it could really harm them in a subsequent proceeding. We agree with the opposition that it would be really helpful to have somebody from NHTSA weigh in on this. But at this point, we'd like to review the amendments. And thank you very much.
Got it. Thank you. Is there public comment in opposition? Seeing none. Questions or comments from the panel? Mr. Lowe? No? Mr. DeBobne?
I actually have a question for each side. And maybe I can start with Cliff or Mr. Gordon. It seems that this would obviously affect, obviously, new car dealers and those that sell on used car lots. We also have a growing marketplace where people are selling cars directly, third-party private buyers. How would this law affect their requirements when they're selling a private car, or also if they're in the business of selling cars? I mean, if they're not, right now I've seen people that are kind of popping up selling cars over the internet. You can buy a car on Craigslist. You can buy a car through a number of different websites. It's obviously not on a dealer's lot. How does this change the requirement? I know we have odometer reading requirements for individuals selling cars. How would this affect that? And afterwards, I do have a question for the consumer advocates as well.